Hey, good morning, guys. Well, we got some more contract terminology coming up for you. I got a bunch of contract terms to go over, so I'm going to get right into it. Thank you for coming, and hopefully this video will help you in your endeavor to learn about real estate terms. The first card I have is what is a power of attorney? Okay. A lot of people think it is an attorney, but it's a designation. A power of attorney is a contract in which one person gives another person the right to act for him or her. The power of attorney may be general, covering all matters, or limited, valid only for specified types of transactions. You may see this abbreviated as POA. Power of attorney. Okay. Next, we have what is an attorney in fact. What is an attorney in fact? An attorney in fact is a person who holds a power of attorney. The attorney in fact is authorized to act for another person under the power of attorney. Those power of attorney and attorney in fact go hand in hand. You'll see that these go in order, and they kind of intermingle with each other. Must the recipient of a power of attorney be an attorney at law? Okay, so from what we just read, power of attorney can be what? Anybody. Does it have to be an attorney at law? We know the answer. No. No professional qualifications are required to receive a power of attorney. The recipient of a power of attorney may be referred to as an attorney in fact, which is designated from an attorney at law. Okay. So the answer is no. Professional qualifications are not required. The recipient of power of attorney may be referred to as an attorney in fact. Okay. Which is distinguished. I said designated. It's distinguished from an attorney at law. Okay. Attorney in fact, power of attorney, does not have to be a lawyer. Can be, but doesn't have to be. Can anyone other than the owner sign a deed or sales agreement? Again, understanding what the power of attorneys are gives people the strength to do something in your behalf. Yes, a person having valid power of attorney in writing from the owner or a trustee may sign the deed or sales agreement. Okay? If you're not available, you can make somebody available, give them the power of attorney to do so. What is escrow closing or closing in escrow? Okay, we know what escrow is. It's a pretty good understanding of what escrow is. An escrow closing is a type of closing where money and documents are put in the hands of the closing agent before closing. At other closings, the seller brings a deed to the closing and the buyer brings money. And these two terms are exchanged simultaneously. Escrow closings are often used in the states where a deed of trust is used instead of a mortgage. For example, Eileen sells her land in California to Connie. The title company acts as the escrow agent. Elaine surrenders the deed to the title company, and Connie gives the purchase money to the title company, thus affecting an escrow closing. Neither Connie nor Eileen need to be present at the closing, as the title company closes the escrow using escrow instructions. Okay. So the title company processes the escrow. Basically, think about it as an intermediary. What is a closing agent? All right, closing agent is a third party. That is someone other than the broker or sales agent or seller. So it's a third party who prepares the paperwork and often conducts the closing or settlement. The closing agent can be a title company, an escrow agent, the mortgage lender, or an attorney. Okay? So the closing agent can be a title company, an escrow agent, a mortgage lender, or an attorney. That's a closing agent. What are closing settlement costs, and what are some typical ones? Closing costs, you think of points, right? Transaction fees, there's a bunch of them. Closing costs are various fees and expenses payable by the seller and buyer at the time of real estate closing or settlement. Some that are typically encountered in a real estate transaction are commissions, lender discount points, title insurance, deed recording fees, loan prepayment penalties, inspection and appraisal fees, attorney fees, transfer taxes, okay, income and expenses that have occurred but not yet received or paid are included, designated as accrued, which we discussed earlier. But again, these are closing costs called settlement costs, okay? These are all the costs associated with closing. Brokerage commission, lender discount points, or points, title insurance, deed recording fees, loan prepayment penalties, okay? All those things. You can always, again, stop and take notes, go over. What does closing statement or settlement statements look like? Okay, this comes usually 2 or 3 days prior to the closing. Table below shows an abbreviated settlement statement. Okay, you have sellers on one side, buyers on the other. It's called a HUD-1 statement. Important. It's going to be on, it's a common closing piece of paperwork. HUD-1 statement has the seller on one side, buyer on the other. Okay. It's a little more detailed than what they're showing you on this card, but it basically a debit's credit. Okay. All your costs, called a HUD-1 statement. Okay. That is, what is a closing statement? It's a HUD-1 statement. What is a closing statement or settlement statement? I guess the previous one was, what does a closing statement look like? This one here is, what is a closing statement? So this will explain the detail of a closing statement. Closing or settlement statement is an accounting of funds from a real estate sale made to both the seller and the buyer separately. The statement itemizes the amounts the buyer will pay and the seller will receive. Most states require the broker to furnish accurate closing statements to all parties involved in the transaction. The statement is also prepared by a lender or title company on a HUD-1 form. And again, this is something received prior to the closing, typically, I believe, 48 or 72 hours. Okay, give you time to look through and make sure things are right. Okay, so that's the closing settlement statement definition. What is a closing date or settlement date? It's an agreed upon date. We'll check this out here. Closing settlement date is the date in which the seller delivers the deed and the buyer pays for the property. The sales contract generally states this date. The sales contract generally states this date, at which time the parties will meet and settle all accounts necessary to transfer the title to the property. Closings are commonly held at a title company, attorney's office, bank, or a mortgage company. Okay. How all these keywords tie into each other. What is a closing statement? What is a closing or what is closing or settlement? This should be an easy one for you. It's the act of transferring ownership of a property from seller to buyer in accordance with the sales contract. It's a closing. Okay. Time when closing takes place. Abel agrees to purchase a property from Baker. A closing is set out for June 15th, at which time Abel will pay all expenses necessary to acquire the ownership and secure financing. Baker will sign a deed and pay the seller expenses. Okay, that is what is closing. What is closing? Some of these things might sound easy, but they all tie together. And very important to know these. These are general definitions. The sales contract calls for the closing to be in five business days later. What is a business day? The sales contract calls for the closing to be five business days later. What is a business day? I believe a business day is a bank day. A business day is a standard day for conducting business. It excludes weekends, Saturday, Sunday in the United States, and holidays. For example, Monday, July 1st, Abel agrees to buy the real estate, closing to be in 5 days, which is July 9th, as shown in the table below. So we know that business days does not include Saturday, Sunday, or holiday. That's a business day. What is novation? Again, these are all under contract. We get one more card here, and then we're going to have to wrap it up here. What is novation? Remember, novation, new. Typically a change in the contract. A novation is a three-party agreement whereby one party is released from a contract and another party is substituted. A novation is often required in conjunction with assignment of debt contracts. An example of a novation: Baker wants to buy Abel's home and assume the mortgage. Abel wants to be released from all mortgage liability. Good Money Savings Association cooperates, and all three parties sign a novation where Baker is substituted for Abel on the mortgage. So in regards to novation being new, there's a new party taking over the mortgage. Novation, new. Another use for the word novation is to mean substitute of one contract for another with acceptance of all parties. Okay. Hey, thanks a lot, guys. Take your notes, rewatch. In regards to learning and maintaining the knowledge, in regards to studying how to learn, give yourself a break, rewatch, something about 25 minutes, 20 minutes break. Go out, exercise, come back, watch again, that type of thing. They say 3 times lady, so and that'll instill it in your mind. I'm going to try to keep a good pace on these, okay? And I've been asked to by some folks, and that's what I'm going to do. I think this is a good pace. We got some good cards done here, and okay. Hey, thanks a lot, and talk to you soon.